Good day everyone, this is Junaid Khan, a regulated Canadian immigration consultant, also representing my clients to the Immigration Refugee Board of Canada. The topic today is important in a way that I have seen few applications in my consultancy. People are consulting about their applications for the sponsorship in Canada, where they have put in their applications already, but unfortunately they are not supposed to sponsor somebody in Canada because of different circumstances. So in today's video, we will be talking about what it means to be a sponsor, and if someone is sponsoring, there are two things important there, that who are they sponsoring, plus their undertaking and their agreement about this. Second point, we will be talking about who can actually sponsor somebody and who cannot sponsor somebody. So what are the main differences and what a person should be to be eligible for us as a sponsor, and who are not eligible as a sponsor, being a permanent resident or a citizenship of Canada. So when it comes to what it means to be a sponsor, so it mainly deals with the family class application. So you can only sponsor in Canada if you are a permanent resident or a Canadian citizen, but you can only sponsor your spouse, your common law partner, your conjugal partner comes into this category, plus you can sponsor a child of yourself or your partner's child. So these are the only people in Canada they can sponsor somebody from outside Canada. But when it comes to the sponsorship, there are two things important. Number one, the undertaking. Number second, the sponsorship agreement. So when it comes to the undertaking, the person who's sponsoring somebody from outside Canada, they have to sign an undertaking that this person is going to be responsible for the people who are entering Canada on his sponsorship. So there are multiple times there are going to be a sponsorship for a period of couple of years. Let's say if we are talking about if a person in Canada is sponsoring a spouse, common law partner, or a conjugal partner, that person is responsible for them for 3 years. Secondly, if you are sponsoring a child which is 22 years old and above, then again, the person who is sponsoring is responsible for their well-being for 3 years. And on the third, if you are sponsoring a child which is under the age of 22, then you are going to be responsible until they become 25 years old or 10 years from the date you are signing this agreement. So this is the important timeline, and most of the time, most of the clients who are sponsoring their spouses and their child, they don't really know this time period, and you must know this time period. This is very, very important. And what comes next in this, like if you're sponsoring somebody, then you are responsible for what they are doing in Canada. Especially, let's say for an example, if you sponsor a person in Canada, they take a loan and not paying back, the Immigration Canada or CBSA or CRA is going to be knocking on your doors, because you have signed the undertaking that you are sponsoring them for 3 years, and in some circumstances for 10 years or until the age of 25. Now, one important thing here, let's suppose that you have sponsored somebody and they become a permanent resident of Canada. There is no way you can cancel or shorten the period of your undertaking period. So, if somebody's applied for a spousal immigration and the person came to Canada already and now they become a permanent resident, you cannot really cancel your sponsorship. You have to take care of that and the period I have mentioned already in this video. So you're responsible for the entire undertaking period, even if, now I'm quoting this from the IRCC website, the people you're sponsoring become Canadian citizens. So let's suppose a person you sponsor to Canada and they become a Canadian citizen, but the sponsorship period is not ended yet, you are still responsible. The second number, your relationship with the person you're sponsoring changes. It happens multiple times. I've seen in Canada that somebody sponsored their spouse, and after coming to Canada, their marriage breaks, or they're not together anymore, or any sort of change in the relationship doesn't really break this undertaking. You are still responsible for the period of time IRCC mentioned. Third situation, you or the people you are sponsoring move to another province or country. So let's say if you're sponsoring somebody, and they came to Canada, spent some time over there, and then they moved to another province, which is still in Canada, you are still responsible of the undertaking period. But even if they move back to the home country or any other country, the period is not going to end there. You are still be taking care of the undertaking period. Your financial problems, let's suppose if you become a jobless somehow, and for example there is a debt, doesn't really change the undertaking period. Plus, if you try to withdraw your sponsorship application, or try to withdraw the spousal sponsorship application, any sponsorship application, the IRCC consider your withdrawal application before the person becomes sponsored already. That means before the visa application is approved. You can still cancel your application, but once the visa is approved and once the person is already landed in Canada under your sponsorship, you are going to be responsible for the undertaking period, which is 3 years, and in some period 10 years, or until the age of 25. Now, let's talk about the sponsorship agreement as well. So in this sponsorship agreement, you're basically agreeing to IRCC, the person you are sponsoring, you will be taking care of their daily commodities, their food, their clothing, the shelter, eye care, dental care, etc., etc. But there is a circumstance, the person you're sponsoring still works or try to do their best to accommodate themselves. It's not like if you sign the sponsorship agreement, that means the person you're sponsoring doesn't have to do anything and you are liable or responsible to provide for all of their needs. But they are supposed to be doing their best to support themselves. So this is very important circumstance. I believe most of the application for the sponsorships in the spousal cases, conjugal partner cases, they neglect these part, and a person should know. In my consultation, if someone calls me up, or we're doing a consultation about the spousal sponsorship, I also and always tell them initially on a very first day of the consultation that you are supposed to be signing the sponsorship agreement and undertaking as well. And I always ask my client if they are ready for it. So moving forward to the second point, which is who is eligible, who can be a sponsor and who cannot be a sponsor. A common misconception here in the topic of who can be a sponsor, that people think if they are a permanent resident of Canada or a citizen of Canada, they are good to sponsor anybody as a spouse or a common law partner or a conjugal partner. So first of all, who can be a sponsor? A person should be 18 years or older. Definitely, a person must be a Canadian citizen or a permanent resident of Canada. Number 3, living in Canada. There are some circumstances where a person is not living in Canada, they can still sponsor their spouse, common law partner, or conjugal partner. In these cases, I'm quoting from the IRCC website, like if you are a Canadian citizen living outside Canada, you must show that you plan to live in Canada with the person when you are sponsoring them. So if you're currently living outside Canada as a Canadian citizen, a lot of people live in Middle East, a lot of people live in US or different countries because of their work, jobs, businesses. But at that time, you can still sponsor your spouse to Canada to become a permanent resident of Canada. But you have to convince an IRCC that you yourself, while living outside Canada, once this application is approved, you will join your partner in Canada and you will reside in Canada. It's not like you can get a permanent residency for your spouse in Canada while you are living outside and planning to continuously living outside of Canada. Secondly, if you are a permanent resident living outside Canada, you cannot sponsor. So this particular point is only valid for Canadian citizens. So if a person is a permanent resident of Canada, living outside Canada for whatever period, for job, businesses, whatever, they cannot sponsor. You have to be in Canada to proceed with your application. Yes, if you are a citizen, you can proceed with the application, but you have to show your intentions to IRCC that you will come back to Canada and you will live with your partner in Canada. Next point, for a sponsor, you have to commit for supporting your sponsoring while signing the undertaking and the sponsorship agreement, which we talk about initially, and you also required to fulfill all the requirements of the IRCC. In some cases, there are income requirement as well. In most cases, if you are sponsoring your spouse, common law partner, or conjugal partner, there is no need to show your income, like in a super visa or other categories where you have to have a certain amount of income according to the low income cutoff. But in the sponsorship of your spouse or under the family class, you don't really have to show that you have to fulfill the income requirement. Again, this all information is for other than the province of Quebec. If there is a Quebec application, then things are a little bit different. Now let's talk about the people who are permanent resident or citizen, but they still cannot sponsor a spouse, common law partner, or a conjugal partner. So like I said earlier, it's a very common misconception. People think if they are a Canadian permanent resident or a citizen, they can always sponsor their under the family class. But there are certain points. If any of them belongs to you, that means you are not eligible currently to sponsor your spouse from outside Canada. So let's talk about that. Some of the points I'm going to be quoting directly from the IRCC website because I don't want to add stuff from my side. So the person who cannot really sponsor a spouse. So first point, the sponsored by a spouse or partner and you become permanent resident less than 5 years ago. So let me explain this. So let's suppose if I am being sponsored by somebody to Canada and it's been less than 5 years, I cannot sponsor a spouse. So let me put it that way, that if I got married and sponsored by someone in Canada and we're not living together anymore, and now I want to sponsor another spouse, I cannot really do it for the period of 5 years. It has to be past the period of 5 years, and after 5 years, I'm going to be eligible for that. Second point, so that's the first point. And the second point is sign the undertaking for previous spouse or partner. Suppose it has been 3 years since they become a permanent resident, which means that you are still financially responsible for them. So basically, like I said earlier in this video, if you have signed the undertaking for the 3 years, you have to wait for that period to cross before you are sponsoring another person to Canada. You may not be eligible to sponsor your spouse, partner, or child if have already applied to sponsor the same spouse, partner, or child, and the decision of the application hasn't been made yet. So you cannot really put two sponsorship applications at the same time. If the decision is not made yet, you have to wait for the decision from the IRCC. A person who's a permanent resident citizen still cannot sponsor if are in jail or a prison, and if you are behind the payments of immigration loans or a performance bond, Plus, you are still not eligible to apply for the sponsorship if did not give any financial support you agreed when you signed the sponsorship agreement. I mean, if you have signed the agreement and you're not fulfilling it, you are not eligible to sponsor. Another point which is very important, which most of the time neglected by a lot of people and they face the consequences. If a person declared bankruptcy, they're not eligible to sponsor a spouse, common law partner, or a conjugal partner. So that's another point. Another point I'm quoting, that if you're receiving social assistance other than disability, that's an important point. I have seen a lot of people, I have seen a lot of it in a lot of cases. So if you are taking a disability payments from the provincial government, federal government, that is fine. But if you are receiving social assistance other than the disability, then you cannot really sponsor a spouse. That clearly shows that you cannot financially take care of yourself right now. So it is going to be impossible to sponsor somebody and then sign the agreement and the undertaking that you will take care of themselves as well. Last but not least, if you are convicted of a violent crime offense, an offense against casually bodily harm, sexual offense within or outside Canada. So if there is a criminal charge or conviction, basically, you cannot really sponsor somebody. And the last but not least, can't legally stay in Canada and must leave the country because you received a removal order. So if you are already an objective removal order, you cannot really put in the application to sponsor somebody in Canada, because end of the day, you yourself is going to be agreeing to the removal order and leaving Canada. So again, I think there are very common misconceptions in Canada. I have seen in my consultation where people do not really know about who can be a sponsor and who cannot be a sponsor. Plus, the financial agreements you have to sign with the IRCC, and there are many questions rise, especially for the people who have already been sponsored before and now want to sponsor another spouse or common law partner. So I hope this video helps you out to understand how sponsorship works in Canada and mainly works in a family class application. Thank you very much.